let us say you were the decision maker, and the upshot of all this was that Mr. Karim ends up not testifying at all as a decision maker. And faced with the evidence that you have, how would you handle that evidence? I think it would be quite odd if, for example, we were suddenly to say, a lot of evidence was heard before the commission, but because Mr. Karim could not have his last word on it, therefore, everything that relates to the bit in respect of which he did not have his last word will just be ignored altogether. So how, if you were the decision maker, how would you handle the situation? I'm raising this in the light of your point about adverse inferences being drawn.
No, Chair, I think we must disaggregate the adverse inference point. I'm talking about the adverse inference in the specific instance of not participating in a voluntary medical examination. That's what I was addressing. What Chair is putting to me, I think, is something slightly different, which is like, and I've not been an acting judge yet, but when that happens, should it happen, obviously, Chair, what you're putting to me is the ordinary decision-making process that a judicial officer goes to in circumstances where you will weigh probability, credibility, admissibility, and so on. And if you draw an adverse inference at the end stage of your report writing in analyzing the evidence, that can't be objectionable. That's the ordinary rules of evidence as we understand it. So if at that stage you draw an adverse inference, for whatever reason you draw an adverse inference, I don't think in principle that there can be an objection to that exercise of inference drawing. I was addressing the adverse inference point about the prior step regarding the voluntary election. So, in direct answer to you, Chair, if I was the decision maker and it was argued in front of me that an adverse inference must be drawn, that Mr. Karim is a naughty person, so to speak, because he didn't participate in the voluntary disclosure.
You see, that's what I'm trying to get out of the equation. There is an inference is being drawn and becomes adverse because of one saying, because of his failure to testify, we are drawing an adverse inference. That's what I'm trying to say. Let's get that out of the equation and just look at the evidence that's before the commission and then decide what to make of it, just as evidence that's before the commission. Of course, it will be a fact that certain allegations have not been answered, and one takes it no higher than that.
No,
so it's at that level that I'm engaging.
Then we're at Eden.
Not an adverse inference based on the failure to testify, in the sense that maybe he was being naughty. Why would he not testify? So I'm engaging you at the level of the reality is that here is evidence to which there is no answer, period.
But then we're at Eden, because that's what I was trying to draw the distinction on. If Chair puts it to me in that way, and that's the disaggregation that I was, with respect, motivating, you're not elevating the non-participation in the voluntary examination process to say, that's the evidence that you're naughty, I'm drawing the adverse inference. I can accept that. But if it's the second one, which is that it's unanswered allegations and therefore I'm drawing inferences because of the failure to answer, that's the ordinary laws of evidence.
To get to that, what you call an adverse inference, to get to that, I think we would have to first make findings as to Mr. Karim's condition. Otherwise, it's just difficult, I think. I don't know what Mr. Chaskalson will say.
Agreed. And because you'd have to consider potentially credibility or the, as I was saying, credibility, probability, veracity of the version. You'd have to engage with all of that. All I was simply saying about it depends on where that comes in. If it's the first step medical examination, that's where I may have a problem. But if it's the second step, which is what Chair is putting to me, unanswered allegations and what flows from unanswered allegations, To me, that's the ordinary principles of evidence. That can't be objected to. Unless, of course, there's a question of Audi or whatever
All right, you may continue, please.
Thank you, Chair. But the second point I was going to make in respect of these the medical examination and less intrusive means is that, and I say this with due respect, because we're not in Uniform Rule 36 territory, there is no comparable direct access to a witness as far as I understand it. My understanding, and you'll know, for example, in the litigation involving President Zuma and the competency of his medical certificate that he used to excuse himself from another commission, if I'm not mistaken, which went originally in front of Judge Pillay, who might have acted with Judge in the Concourt, but is from the KZN division. There, the contention was not when the commission, that commission, I don't want to call it the Zondo Commission, but you know which commission I'm referring to. When that commission had issues with the medical certificate and the medical fitness of the witness or otherwise, they had to impugn the medical certificate as the first step and potentially the person who authored the medical certificate, because that's the evidence upon which the witness relies to say, I should be excused from giving the evidence. So why I mention that is because what our learned friends say is that because they've come up against this medical certificate as they have, they must go directly to the witness and subject him to a medical exam from someone other than the doctor of his choosing. Whereas what they could do is they could engage the medical practitioner themselves. If they wanted to, they could have, we could have, I say we in the sense of if Chair gives directives to that effect. And again, I'm not committing myself to this version, I'm just theoretically testing the proposal put in front of you, is that we could have an in-camera hearing, because obviously we'd need to test the fullness of that confidential medical evidence, so it can't be for open public consumption. But then that's what we do, and the Commission might choose to cross-examine the particular medical professionals. They might wish to lead the evidence of their own medical examiner, who might give an expert view of the expert view that we've tendered. We might want to cross-examine their own expert. So that what I'm saying is that I'm not immune to the Commission's concerns about concluding the evidence of Mr. Karim. But we've played open cards with the Commission to the extent that we can, by providing all the correspondence, by providing 4 medical reports, giving all the details of all the treating doctors, and before we must leapfrog to subjecting a person to a compelled medical examination, or potentially a voluntary one like Chair says, we must think about the balancing exercise of constitutional rights. And if there is less intrusive means that can nonetheless enable the Commission to do its job, then we would argue from the perspective of proportionality and reasonableness and balance, then that's an available mechanism. May I just make my last main submission? But before I do that, Chair, I don't know if you want to...
Just to say what Chair posits.
Yes.
I think to say says sounds stronger to me. I think there's a nuance there.
Yes, no, then I withdraw every use of the word says, and I rather use the word posits. If the transcriber can edit the transcription, that's perfectly
No,
fine.
they don't need to. It's part of the engagement.
Yes, no, I accept that. And I'm grateful for the clarification, Chair, because also what I'm doing is I'm trying to be helpful to you, Chair, and the Commissioners by engaging the debate and giving as cogent an answer as I can, hamstrung by the fact that I can't commit my client to a version in the absence of knowing the Commission's position and without instructions. So that's the rock in the hard place. The rock on my right and the hard place on my left, perhaps, that I'm stuck between in trying to engage you, Chair. So that's as far as I'm trying to take it. My third and last main submission, if I may, Chair, is that I've heard what my learned friend said about the recommendation for prosecution. Chair already identified mens rea as the requisite element and how that would need to be investigated, and then the prosecution would flow. All we'd point out is we've also addressed this in our letter of yesterday, which I take you got probably very late last night, if not early this morning. And we did say that if that's going to be the case, that the Commission, for whatever reason, chooses to make a motivation to the Commission that a recommendation be made that our client is prosecuted, that we get an opportunity to address the Commission before an adverse decision is potentially made against him, because that's Audi Rights 101. So Chair, that's to respond to what my learned friend said regarding everything else other than the 15th of July date. On the 15th of July date, we are in your hands and we will do as directed. Thank you, Chair. I'm indebted, and I know I've taken a long time, but thank you.
Thank you, Mr. Premier. Mr. Shaskalson?
Chair, I don't want to respond now because this is a debate, if it is ever going to arise, for another day. But I do want to place on record that we don't accept many of these submissions. And in particular, the one worrying thing that we see is what the medical reports disclose is that Mr. Karim has not been hospitalized continuously since April. He tends to get hospitalized just as his appearances before this commission are scheduled, and that is worrying. And it's particularly worrying in the context of a situation where very basic, quite aside from his appearances, there are very basic requests for some documents to be furnished, like financial statements. It doesn't take much to issue an instruction for financial statements of a company to be made available to this commission if you're not in hospital. And what we see is a simple refusal to comply with these notices, coupled with a pattern of, as an appearance date appears, suddenly Mr. Karim needs hospitalization. Now, it may be perfectly true. It may be that by coincidence, or possibly not by coincidence, his medical condition compounded by the stress of an imminent appearance requires his hospitalization. I'm not saying it's not true, but it is worrying. And what is particularly worrying is that very, very basic requests for information have been outstanding since Mr. Karim last testified, at a time when he was certainly fit enough to testify, fit enough to travel outside of the country, and we still wait for the documents that he promised us when he gave evidence. I don't want to say any more now. I'm hoping this never becomes an issue that we need to take further.
Now, thank you, Mr. Shaskalson. For purposes of now, what sort of...
All we want is a postponement
just
until
a postponement
the 15th of June.
Nothing more. Nothing more.
We put stuff on record now so that
Thank you.
Mr. Karim and his legal team know what our concerns are, but all we want is a postponement until 15 June.
Thank you. The hearing of Mr. Karim's testimony is postponed to 15 July 2026. You are both excused.
Thank you, Chair.
Thank you.